Thank you, and good morning for our next panel. We're going to be looking at the possible usage of AI on ex post legislative scrutiny. Just to introduce the idea, I'm Wade Ballou, retired legislative counsel from the House of Representatives. What is the idea of ex post legislative scrutiny? Legislatures, of course, have long used it to review, to evaluate, and to monitor the laws that it passes. These reviews ask, in essence, whether the law has achieved its intended purposes and what, if any, are its unintended consequences. The objectives of these reviews are typically accountability, effectiveness, compliance, administrative and financial efficiency, and acquiring insights to improve the law in the future. The mechanisms legislatively that have been used are reporting requirements, sunset clauses, statutory oversight, and audits, such as in the United States by the Government Accountability Office. However, to my eye, these systems have not been very effective. They're often ad hoc, and again, in the United States, I have observed that they tend to be a very partisan affair. Our panel today is going to open an inquiry into how legislatures can use AI for ex post legislative scrutiny of the laws that it passes. We have an excellent panel to kick this off. And let's see. Okay, so we have Marty, Sinéad, right? Yeah. Okay. Yeah. Ludovic and Daniel, and we will be joined by Andy Beattie from Scotland when he arrives. I understand that he is on the way. My first question for the panel, and I've designed two questions really just for them to begin to give ideas that I'm hoping that we can continue exploring in future conferences. But first question is, what is required for a legislature to add a post-deterministic analysis of the impacts and consequences of the laws that it passes, including testing the extent to which the goals and purposes of these laws are actually achieved? And to kick it off, Sinéad, if I could turn the floor over to you for 5 minutes.
Thank you, Wade. Yeah.
You might get your.
Can you hear me? Yeah. Yes. And when I was thinking about this question and reflecting, I think I couldn't really get past the first step. So I'm not sure if I've fully answered it or I'm still in this preliminary stage. But for me, a primary step that's required, but a fundamental one, is really to clearly define the role that our artificial intelligence will play when considering its use in ex post legislative review or scrutiny. And I think I'm stuck in this point because when we talk about AI and introducing it into a parliamentary context, Parliament is so inherently a human thing. It's about the assembly of people. Democracy is about giving power to the people through elected representatives. In the Irish context, in our constitutional framework, it's very much about the members, the elected representatives having to be present, physically present in Parliament to debate. We had this issue around COVID where there was this debate about introducing virtual parliaments, and it's prohibited by the Constitution because it's so explicitly requires that physical presence. So that's really where I was coming from, and when I was thinking about this, I just felt that when we're defining its use, we need to, I suppose, draw a very clear line in the sand in terms of where it can go and it can be useful, but where it should never go. And so really at that high level, I think that when we're talking about AI support and how it can support in this way, there's, I suppose, high level two types. There's a process-based support, and then there's more a second substantive-based support. And I suppose with process-based supports, that's relatively straightforward. It really involves AI retrieving, organizing, and formatting existing information. And in the context of ex post legislative scrutiny, that's really valuable, I think, because it really would support, because we're often dealing, I suppose, with very large volumes of material, legislation, policy documents, submissions, departmental data. And that really AI would really accelerate that piece of work and the organisation of this information and make it very much more accessible to the members when they're working with this. It would also, I think, really support the work of committees, the practical work of committees and the clerks involved in this, in managing these large volumes of information and allowing them and assisting them in data collection and the administrative coordination and engaging with different departments and stakeholders and citizens. So it could have a really impactful use in terms of allowing for greater participation with the citizens. And I think used in this way, it's really enhancing the efficiencies of committees in this review of its work. The second category, the substantive based, that's where I would have more concern. And that really is where you're using AI to analyse data, even identify trends coming from submissions or data, and generating conclusions about the effectiveness of the legislation. And I think this is moving into an area that really should stay with the elected representatives. It's about the assessment of legislation, about impact of policy, and I would be concerned that that is something that is going to the core of the democratic function and responsibility, and something that our members are constitutionally mandated to do. It's their job. And I think in some ways these are very two separate, clear distinctions in theory, but also there's a danger if we don't define it from the outset and have this clear line in the sand. I think in practice, that line can be easily blurred. And I think a system that begins by organising information can easily move into suggesting interpretations, highlighting patterns, and that's at that point that we're no longer supporting members in their work, and we risk influencing how they analyse it. And then there are other, I think, risks associated with this, so which include manipulation, bias outputs, and the well-documented issues of hallucinations. And that's something that has actually, we've seen play out in our own court system, and I'm sure in your own jurisdictions you've seen it as well. So in a recent Irish case, a litigant in person, or a litigant relied on legal authorities that just didn't exist, and this became transparent in the court process, and the judge set out a number of principles. I think first of all, the judge, and this is something that's absolutely acceptable, is like that there's an entitlement and there's no issue with using AI to support your work in a legal case. But so he added a number of important, I think, and helpful principles that this should be transparent. All parties should know about it. And it doesn't remove, using AI doesn't remove your accountability and your responsibility to ensure those submissions are accurate and correct. And as such, there needs to be an independent verification process. And finally, the court recognised that sanctions would need to be applied where the court is misled. And although these principles were raised really in a judicial context, I think they do offer useful guidance when we're considering introducing it into the legislature and into this committee process. And I think if AI is to be used in this context, it must be done so transparently. And in the previous panel, that was a clear principle that was stated. And in that in citizens, I suppose in practical terms, what does that mean? Well, I think citizens need to know, and it needs to be clearly communicated to them when it is being used, why it is being used, and how it is being used, and when it's not, and where it's not going to be used. So there needs to be clear documentation and communication to citizens on the use of AI within the parliamentary context, because it's so important to how our countries run and operate and core to democracy. There needs to be also clear guidance for those using it, for the members, for the staff, not only on how they can use it, but how they should not use it. And I think critically, from my own perspective, the substantive piece, determining when legislation has worked, really must remain with the human decision maker. And I don't think that's something that we can delegate to a system. And I think even if we are going to use AI tools in the riskier side of what I suppose more riskier side of I suppose the scrutiny, and such as I suppose identifying trends, analysing submissions, this must always be subject to human verification and scrutiny. So I think, in short, AI is a very powerful tool, but it's a powerful support tool, and especially, I suppose, in terms of handling the volume and complexity of the information involved in ex post scrutiny. But I think it's important that it must be carefully bounded, and the process support can and should be embraced, but the substantive judgment, I really firmly believe it must remain with the human democratic function. Thank you.
And thank you. Very, very helpful in setting out that framework. Marty, I'm going to ask you now for 5 minutes.
Thank you. I agree with everything you said. My perspective is a little different than a lot of folks in the room. I've been in the legislative space now for about 2.5 years. I've spent my whole career in Silicon Valley. So I come from a business background and a tech background. And it feels good to be in this space because I feel like I'm actually working on something positive. Before this, I spent 15 years in e-commerce. And it's nice to be able to now tell my teenage kids that I'm not helping retailers fill up landfills, but working on democracy. I know quite a bit about AI, but I think the way it relates to this scrutiny of legislation is really important. I don't believe that we all know the problems, like was just described, about using AI to generate text for us, to generate analysis. It cannot be trusted to do that. Qualitative analysis is not something that it is good at, and that is because it lies. We can call them hallucinations, but if it was a human, you would call it a liar, right? And this is not necessarily a bug in the system. This is not necessarily something that will be fixed, because this is a probabilistic system. It guesses, and it's programmed by the 3 or 4 companies that provide these models to do that on purpose. They could program it not to. If it didn't have an answer, don't give one, right? But the fundamental programming of AI is to make us happy as humans and to keep us engaged. So it will always give us an answer, right? Now, quantitative analysis is different. That's about data. And what the promise of AI always had been, and where we have gotten to, is its recognition of human language. So now we can program AI through human language. We can write code. And when it comes to in the business world, you don't, as a manager, you don't trust your employees, right? You give them license to do what they say is a good thing to do, and then you measure their success based on the data. Did revenue go up? Did you retain your staff better, right? You look at the numbers, you look at the data. And I know that a lot of the scrutiny of legislation is about, did we craft the law the right way? That's important, right? We want to be skilled practitioners of the law. But if we want to measure, did the law have the effect that we expected to, or that the politicians told the public that it would have a certain effect, we should bring data to prove that. And the problem with data is that all data is different. And we spend lots and lots of money in the corporate world to manipulate data to be able to do good reporting. it's data scientists don't spend most of their time evaluating data. They spend 80% of their time writing connectors to transform one piece of data into something that the other system can utilize. AI can now do that for us. So when we talk about AI writing code for us, this is a really powerful tool in Scrutiny, where we can ask it to create connections between data streams and reporting that will tell us first order impacts on did those graphs go up or down after this legislation was passed. We can add second order impacts as well, which are often more important because they're the ones that the citizens care about. Did this make my rent go up? Did this make my electricity bill go up, right? Is income inequality getting worse, right? So these are things that AI can really help us with. It's not the qualitative analysis that we should focus on. From my perspective, it's the major problem of data, getting our data in the right form, connecting it to data streams, and doing that quantitative analysis that can really create dynamic reporting in a very quick way for us. Thank you.
Thank you, Marty. Ludovic, can I call on you with the same question?
Sure. Two mics open. Yeah, thanks. I will be quite aligned with the last presentations that have been made, and I thank you also for being present and not having a tie like me. If we want legislators to move toward a more evidence-based and deterministic form of ex post legislative scrutiny, the first thing we need to recognize is that artificial intelligence alone will not solve the problem. The real challenge is not primarily technological. It is institutional, methodological, and sometimes even cultural. Very often, parliaments adopt legislation without clearly defining how success or failure will be later measured. We define obligations, procedures, reporting mechanisms, and timelines, but we do not always define the indicators that would allow us to evaluate whether the law achieved its intended objectives. And this is essential because AI can only analyze what exists. If the indicators were never defined, if the data are incomplete, or if the information was never collected in a structured way, even the most sophisticated AI system will produce weak or misleading conclusions. This means that ex post scrutiny must begin before the law is adopted. If a legislature adopts a law intended to reduce pollution, improve cybersecurity, strengthen social protection, or accelerate administrative procedures, legislators should already know what will be later measured, who will collect the data, how frequently it will be updated, and according to which methodology. Otherwise, 5 years later, institutions discover that the evidence required to evaluate the law simply doesn't exist in a usable form. We already have concrete examples showing both the difficulty and the value of this approach. Within the European Union, environmental legislation progressively introduced harmonized reporting obligations that allow institutions, such as the European Environment Agency, to compare environmental indicators across member states over time. Without common indicators and standardized reporting structures, meaningful comparative analysis would have been impossible. This is even more important in a federal political system. The second major requirement is interoperability. Legislation rarely operates inside a single administration. The implementation data must be distributed across ministries, agencies, courts, regulators, municipalities, regional authorities, and statistical offices. Each institution may use different formats, different definitions, different taxonomies, and different levels of digital maturity. And fragmentation is one of the greatest enemies of meaningful AI analysis. Artificial intelligence performs well when information is structured, comparable, and traceable. It performs very poorly when institutions operate in a disconnected silos. We have seen this challenge very clearly in Europe through the interoperability initiatives led by the European Commission. The difficulty was not developing algorithms. The difficulty was aligning administrative systems and governance structures across countries and institutions. The third requirement is expertise. Parliaments will need capacities that go beyond traditional legal analyses. They will increasingly require expertise in data governance, statistical interpretation, AI auditing, methodological transparency, and causal analysis. Because AI is extremely efficient in identifying correlations, but ex post legislative scrutiny is fundamentally about causality. And this distinction matters enormously. If unemployment decreases after a labor reform, was it caused by the reform itself? Or by economic recovery? Or demographic changes? Or technological evaluation? Or monetary policy? An AI system may produce very convincing outputs while hiding uncertainty, incomplete datasets, or methodological weaknesses. This risk is not theoretical. In the United States, several studies on predictive policing systems shown that historical biases contained in the datasets could reinforce discriminatory patterns because the systems learn from historical enforcement practices rather than from objective indicators. The same risk exists in legislative scrutiny. If the datasets are incomplete, politically biased, geographically uneven, or socially distorted, AI may simply reproduce these distortions at scale while giving them an appearance of scientific objectivity. Please keep in mind that generative AI is only a probabilistic system, not more. This is why transparency is absolutely essential. Legislatures must remain capable of understanding which data was used, which assumptions were made, what was excluded, and what uncertainty still exists. And ultimately, I do not believe that AI should replace democratic judgment. Its real value is elsewhere. AI can help parliaments navigate complexity. It can help identify weak signals, implementation gaps, territorial disparities, and unintended consequences. It can augment institutional analytical capacity, but democratic accountability still requires human judgment, political responsibility, and institutional humility. Because legislation does not operate inside control laboratories. It operates inside living societies.
Thank you very much, Ludovic. That was very helpful. And before I go to you, Daniel, I want to say a big welcome to Andy. To help orient you, I'm on the first question and giving you a moment to kind of collect yourself here. And while that happens, I'm going to turn it over to you, Daniel, with the same question.
Thank you. It's fun to be on a panel that's so interesting that it keeps adding members as we go. and I'm just appreciative to, just so glad to be here. So, as is my wont, I'm going to start by questioning the premise. I hope you don't mind too much. We're talking about, of course, ex post scrutiny. In the American context, which is what I'm most familiar with, I'm not sure that's a thing that we do anymore. So we might be ex post scrutiny. That's not funny, maybe. So if you watch a hearing in the House of Representatives, you have this interesting phenomenon where someone will come in and they'll ask a question, and the witness will answer or not answer the question. And then you have the next member of Congress comes in and asks the same question. And you have this phenomenon for 2 or 3 hours, at which point the hearing concludes and nothing has been learned. Because the members are showing up for the time to ask their question, they're asking their question, and they're leaving, and they're not listening, not necessarily to the answer, and they're certainly not listening to what the people have said before them or afterward. And then, of course, because we have committees in the House and committees in the Senate, you have the same thing happening on the Senate side at some other time. For folks who didn't watch the House proceedings, we have authorizers and appropriators. They also don't watch each other's proceedings. They often don't know each other. So we get the same question or the same 2 or 3 questions again. So Gen AI might be helpful in the sense that maybe we'll get a greater variety of questions. That would be nice. One of the requirements for witnesses when they come and speak is that they have to give 5 minutes of opening remarks. And the reason you give 5 minutes of opening remarks is because no one is expected to have actually read the written remarks that were provided in advance of the proceedings. Okay, what are we doing here? Right? This is, you know, we have Oversight Committee in the House. We have the Homeland Security and Governmental Affairs Committee has a Permanent Select Committee on Investigations in the Senate. Most of the committees have their own investigative elements. If you don't get your questions asked at the proceeding, when you wait your 2 hours to ask your question for 4 minutes, you can submit a question for the record called a QFR. Questions for the record are then sent to the witness. The witness will more or less answer the question or not. It will be sent back, and between 2 months and several years later, it will be published in a committee report, which nobody reads except for me because I'm stupid. And there is no good way to extract the information from the committee reports from the questions for the record. So if you have the chairman of the Federal Reserve who comes and testifies and answers a number of questions, and they come back the next year, has anyone looked through any of the questions and answers that have been asked previously? No, of course not. Has anyone gone through and looked at the questions for the record? No. The only place that this is not true is the Judiciary Committee in the Senate, which is looking at federal judges and is trying to find where they may have expressed any opinion on anything ever in the history of the world, at which point that becomes a thing which is the basis to prevent them from becoming a federal judge. But beyond that, we don't really do that type of thing. We do have agencies that are set up to engage in ex post scrutiny. The Government Accountability Office is one. It's an $800 million a year legislative branch agency that is currently under threat for a 25% cut in its funding, and will have to fire several hundred people this year. It has AI capability, it engages in analysis. It is something that is building up. But this is on an ad hoc basis. So it conducts its investigations as follows. First, investigations that are required by law, which generates a report 1 to 2 years later that few people read except for the couple summary pages. Requests from members of Congress, at which 1 or 2 members will receive it in advance, which is a great 100-page document that is really useful to boil down for a press release. And then, of course, when they've done other work that's beyond that, they get yelled at by the members for doing the work that is actually helpful. Because when you provide an analysis that's based upon facts and not based upon opinions or based upon vibes or based upon whatever other basis one might use, if you dare come to a conclusion, there will always be someone who is unhappy about that. And the person that is unhappy about it will then use that as an opportunity to try to mess with your funding. Which creates a tremendous disincentive. I used to work for the Congressional Research Service, which was part of the Library of Congress. I jokingly say that my job was to provide bad legal advice to members of Congress, which was not what the statute said, but what sometimes happened. And when I started there, our job was to provide advice that was authoritative, nonpartisan, reflected our expert perspective. But after doing that too often, the agency's funding was threatened, and now we provide advice that is, on one hand, the earth is flat, and on the other hand, it's round, and it's up to you to decide because we're not going to tell you. AI is useful for addressing some of these issues, which is, of course, the point of the panel. And I'm trying to be good about timing, so please let me know if I'm running past it. It can find and analyze all the questions for the record. Has this question been asked before? That is a good use for AI, right? You can cluster questions together. You can, when I draft questions for members of Congress, I'm not great at writing question language. AI is really good at making it sound like something that a normal person could actually say, instead of the presentation that you're hearing from me that is discursive and rambling. It isn't very good at leading a witness down the garden path, where in 3 minutes you can actually get them to say something that they would never want to say. It is useful at building deterministic tools. When you're trying to analyze data, we are in the process, of course, of killing off our data sources in the US, but to the extent that you have authoritative data that you can still trust. It is good at building bridges across the different data sets, building the Rosetta Stone so you can connect one data set to another, and creating analytical tools so that people who spend days, weeks, months, and years trying to analyze data can now do it in hours, minutes, and seconds. And that will at least give you something that is directionally relevant to try to figure out if things are going in the right direction or not. The final place that, and then I will conclude, which I'm sure will bring applause from everyone, which is the question of, what is the intent of the legislation in the first place? You have 435 members of the House, you have 100 senators, 20,000 lobbyists. What is the intent of the legislation? The legislation tells you what it says. The federal courts will tell you what they think the legislation said, but they will do that without actually reading the debate. and then you're trying to analyze what its effects are in the world, where, as Ludovic indicated, as it turns out, there are more factors than just the legislation itself that can affect the outcomes. So as we're trying to figure out the effects of the intent of legislation as it's being implemented and then evaluate its effects on the world, to figure out whether we did the right thing or the wrong thing, we're doing this through a political lens whose responsibility, at least in the US context, is more about assigning blame than trying to figure out what happened. And AI is really good for that because it'll write your press releases. And with that, I yield back.
Thank you, Daniel. Before I kind of make any particular kind of conclusion and bridge into the next question, Andy, if you would like to weigh in.
Absolutely, Wade. Always nice to see a friendly face when you arrive somewhere late. Apologies for my tardiness, not just at the conference, but also today. I hot-footed it across from Edinburgh this morning, but once we got on the plane, the pilot refused to take off before he could close the airplane doors. I was quite glad that he waited for the doors to be closed, but it did make me a bit late today. If I was a bit of an expert in airplanes, I might have managed myself. So I'm Andy Beattie. I am the Chief Parliamentary Counsel in Scotland. I'm not a technology expert. I'm not really a massive expert in post-legislative scrutiny. So you might ask myself, why have I spent so much time this morning getting here? Well, what I am is I'm a legislative drafter with a real enthusiasm for technology, but also in particularly an enthusiasm for improvement and improving legislation in laws. And I always approach improvement from a perspective of feedback. I think feedback drives improvement, so that's how I will answer the questions today from that perspective. You must wonder how I know what the question is. It's because Wade kindly shared it with me beforehand. I didn't hear it from afar. So for me, this question is not really whether AI can be used to tell us whether a law has succeeded or whether or not it is a good law. The challenge is whether the conditions exist that would allow AI or any other digital tool or even humans to carry out a meaningful assessment in the first place. If there's to be meaningful post-legislative scrutiny, there needs to be clarity about what the problem any piece of legislation is intended to address and what success might look like. Legislation itself needs to be clear and have measurable objectives. Now, some laws are enacted with quite clear and specific objectives. They can be quite specific, but others are enacted with quite broad ambitions, things like to improve public safety or promote economic growth. Now, these might be entirely appropriate political objectives and described as one of the things that the bill for the eventual act is supposed to do, but of course they can be very difficult to evaluate because of the system in which the law eventually fits. So, in other words, if a specific legislative objective can't be easily ascertained at the outset, neither humans nor artificial intelligence will be able to determine later whether that legislation has properly achieved its aims. But where the right conditions exist and there is a clear and specific aim, there is undoubted potential for new technologies to help us to become better at learning how the laws that are passed are operating in practice. A common difficulty with post-legislative scrutiny is that the evidence of legislative impact or the effectiveness of law, or whether it's good in a technical sense, can often be fragmented across different institutions and collected in different forms, whether it's government reports, parliamentary inquiries, and court decisions, and academic papers, so on. A real opportunity for AI, as we all know, is its ability to help us identify, collect, and analyse evidence across all these different sources at a scale which really wouldn't be possible, or certainly at a scale and speed which wouldn't be possible otherwise. But perhaps an even bigger potential is that using AI offers the possibility of switching from episodic reviews to continuous learning. And as I say, I think continuous learning is the real heart of improvement. So instead of a law being reviewed every 5 years or 10 years or whatever is required by legislation or convention or whatever, AI can help us to continuously monitor implementation, to monitor impact, to monitor any unintended consequences through court decisions. And this can create what I would call a systematic feedback loop between legislative intention and the real world outcomes. So I think that's the real benefit. I'm not entirely convinced that legislative success can ever be entirely assessed with deterministic analysis, using AI or otherwise. Any law, any legislation will always operate within a complex societal system. The laws are, of course, the rules which govern our societies. They fit within a society, and once they're operating, they have to operate in that complex environment and world in which we all live. And it can be quite difficult to isolate the effect of a single act or a single legislative provision from all the other influences that are operating at the time. You know, was it because the law was passed that this changed, or was society changing it anyway? It can always be quite difficult. But what AI can do is help us identify patterns, correlations, and evidence. Whilst it will do that, and as I say, if it can help us do this systematically, it's good. I think I would always just conclude by saying that deciding whether legislation has succeeded will ultimately always really matter, or remain a matter of political and ultimately democratic judgment.
Thank you, Andy. I kind of think the panel has already been very helpful in setting out framework and setting out limitations on what AI can do and can't do, cautions and risks. And that takes me into the second question, is that many of our legislative entities receive information from the government, from the executive branch. Some of these entities themselves also produce information through formal and informal audits that they make of the government. Today, this information, I have found, is often siloed at the entity level and is not necessarily provided broadly in the legislature itself. It may not even be in useful electronic form as data. So the question I have for our panelists is, what institutional structures are required for this information to be available to effectively serve the legislative process? And we'll go in the same order as before. So, Sinéad, if I could talk to you first.
No problem. Yeah, I agree. I think when we're talking about committees and scrutinies, a lot of the information required for effective scrutiny, whether it's executive data, parliamentary submissions, audit outputs, it's all fragmented across various institutions and siloed. And it can be inconsistently formatted and not always accessible, which really limits the ability of legislatures to build a comprehensive evidence base to measure the impact and effectiveness of any particular legislation. But AI does offer a powerful opportunity to address this, as I mentioned previously, in terms of that process side of things, as it can collect vast volumes of data and archive, label, organise it in a way that is accessible and more efficient. However, I think to really properly realise that, there needs to be a lot of institutional reform. And as a lawyer, I'm just going to focus on the legal and governance frameworks that I think are essential, or two core legal, and there will be a myriad of them, but in my mind, there are two very central ones that we would have to think about when we're talking about using AI to, I suppose, process and engage with the data itself, but also the types of data we're talking about. So in terms of, I suppose, the first piece, and within the European context, we are bound by the GDPR, which is the General Regulation Data Protection, and that really is very strict laws that regulate how we process personal data. And obviously, when you're engaging with citizens on witness submissions, you will get volumes of very sensitive special category data, such as political opinions, health information, that requires even enhanced protection. And importantly, and recently, it's now very well established that Parliament and parliamentary committees are bound by the GDPR. This means that any AI enabling processing of such data must be fully compliant with this. And so when we're talking about introducing AI to even just process and hold this data, we really need to embed the data protection compliance from the outside of any of these projects. So it's really by design default, and to ensure that the compliance is really inbuilt from the outset and not retrofitted at the end. It's so fundamentally important. Also, there needs to be a thinking around roles and responsibility, because we have multiple actors here. We have parliaments, governments, audit bodies, we have external AI providers, and therefore we need to, and we're bound to, identify and understand who controls it, who processes it, and if there's a joint controllership. So here again, from the very outset, you need to identify and define clear lines of responsibility to ensure legal compliance, create formal governance arrangements and clear legal agreements in terms of sharing this cross-institutional data. And third, and actually particularly important in relation to AI programs and use, there needs to be very strong technical and organisational safeguards to prevent unauthorised access of this data, and clear policies on data residency and data sovereignty. And this is particularly important for the GDPR, because personal data cannot be transferred outside the EU where we're inadequate, where the third party or a third country doesn't have adequate level of protection of personal data. So the introduction of AI to support ex post legislative scrutiny here really needs to consider these very important data protection rules, specifically in a European context. Another relevant legal institutional kind of requirement, I think, is but also potentially a very helpful roadmap for introducing AI into Parliament, is the EU AI Artificial Intelligence Act, which is now in operation. And the AI Act seeks to regulate the use of AI within various member states of the EU, and it's helpful because it sets out very core, in terms of a roadmap, it sets out very clear principles such as the importance of governance and accountability, or the need for governance and accountability. So ensuring that Parliament has a central coordinating function that oversees and aligns with will soon to be the AI office in Ireland in terms of deployment, ensuring compliance, accountability of any programmes that it's using in its scrutiny work. Also, the AI Act makes clear that AI programmes must align with fundamental rights and democracy, which is again particularly important in a parliamentary context, which again means that AI should support scrutiny by improving the evidence, but never substitute or be seen to shape political judgment. The AI Act also introduces a risk-based approach, which is helpful when considering the various programmes that a Parliament may wish to use. So some tools used in scrutiny, and particularly those analysing public behaviour, even identifying trends, I would say, or politically sensitive data, may fall within the higher risk categories and will require additional safeguards, such as the requirement for human oversight, a fundamental rights impact assessment at the outset, and clear procedures to override and question any AI findings. And finally, it's very strong on the need for transparency. So when AI contributes to reports, briefings, or public-facing outputs, this needs to be clearly disclosed. So I suppose, in short, to ensure that this works properly, I would say that the legal kind of compliance issues really need to be considered at the very start of any kind of introduction to programming of AI. Thank you.
Wonderful, thank you. Marty?
So I think this is one where I probably don't have a whole lot to contribute in terms of how to get different groups within a government to share data that they have, right? But what I will say is that I think that what we're trying to get to here is our facts and truth. And so, this is something that shouldn't be whenever in business, whenever you're trying to get two groups to communicate and work together, you don't attack them on a tactical level. You go after a higher form, right? So this is really a moral concern, and from my perspective, that the citizens deserve to know the facts of what's going on. They deserve the data. And the data is, the facts are something that I think we all struggle with today, at least in the US. Knowing what is true and what is not true is something that we're struggling with. And I believe that democracy itself will struggle if we don't know what the truth is and we don't know what the true data is. So I think if we want to protect democracy, we need to have the will to share our facts with each other and evaluate them together. I agree that with the panelists that causation is something that's extremely difficult. We're in a very complicated world. Are things related to one another? Absolutely. And we should use our own selves, our analysis, human analysis, to make those decisions about causation versus, are things just related to one another? We should never rely on a probabilistic program that is designed to keep us happy to do that for us. I also, I think what Ludovic said is extremely promising. If you can build a system with AI that easily connects or quickly connects data sources and provides reporting that can be related to acts that are taken by a parliament, that same system can be used to create scenarios and project changes to data streams in the future, right? It's the exact same system that we create to measure that can also be then we run scenarios through to project what will happen. And I think that this is an opportunity. Some of the largest companies in the world have been doing this for decades. Shell Oil Company, for example, is famous for scenario planning and has spent, even in as early as the 80s, we're spending millions of dollars building complicated deterministic systems to project the outcomes of their decisions. That is an opportunity for us today, and it may be the type of thing that where we've moved to a combinatoso, we then move to legal rule ML, and now we've got an AI system that does the dirty work of connecting the data streams to one another. This holds the promise of not only showing us the data that we can layer our analysis on top of that we don't have access to today, but it also allows us to project the outcomes or scenarios that might, potential outcomes of legislation that gets passed. In order to get everybody to work together, sometimes you have to go above the politics, if you will, between the different groups and provide a vision for something that they could realize that maybe they do want. I also think that this kind of thing isn't today not limited to governments. Corporates can do this as well. So we may find that in the next couple of years, we're going to see public systems, corporate systems that are able to project the outcomes of legislation. Scenarios, not projected, but what might happen. And I hope that that does happen and that does affect public debate. Because I think what we're really trying to measure is not the outcome from my perspective. What I'm interested in measuring is not the outcome of, is it the intent of the actual bill that gets passed? It's the intent that gets messaged to the citizens, right? Because those things, at least in the US today, are not the same. They'll tell the public, this is what we're trying to do. That's not the legislation they're pushing through. So I'll leave it there.
Oh, I very much appreciate that. Ludovic, would you like to follow up? And same question?
Same question but different answer, even if it's inspired by the previous ones. Well, I believe that this question touches one of the most important dimensions of artificial intelligence in parliamentary work. Because before discussing AI, as it has been already mentioned before, so we first need to discuss institutional memory. Some of you will remember that I was head of archives of the Parliament one day. So I was in charge of keeping this institutional memory for my institution. But today legislators possesses enormous quantities of information related to the implementation and evaluation of laws. There are audit reports, implementation reports, scientific studies, parliamentary questions, constituent feedback, budgetary assessments, court decisions, regulatory opinions, and oversight documents produced by many, many different opinions. And we even had exchanges during the dinner yesterday about how to try to group all these ones and to have systems that would better reflect the diversity of all this amount of data produced but almost never used. The problem is not often the absence of this information. The real problem is, again, what was mentioned before, fragmentation. Information is frequently distributed across institutional silos that do not communicate effectively with one another. And this is even worse in federal systems. Again, I insist a little bit on that. Some information remains on paper, some exists only in PDF documents, some is stored in disconnected databases, some is inaccessible outside specific committees or administrations. And in many, many cases, institutions themselves no longer acknowledge they already possess. Artificial intelligence can help enormously in this context, but only if appropriate institutional structures exist around it. In my view, the first requirement is the creation of trusted knowledge architectures capable of preserving, structuring, indexing, and retrieving institutional information over time. Some of them could be archives, but we could have all the means to preserve these ones. In the European Parliament, we developed Archibot precisely to address this challenge. The objective was not to replace human expertise, but to make decades of parliamentary archives accessible, again through multilingual AI-supported retrieval mechanism. This type of approach becomes particularly important for ex-post legislative scrutiny because implementation evidence often appears years after legislation enters into force. If institutional memory is fragmented, the capacity for meaningful oversight progressively disappears. The second requirement is standardization. Artificial intelligence depends heavily on consistency and interoperability. We mentioned it already several times. If institution exchanges information using incompatible format, disconnected metadata structures, or inconsistent legal references, the evidence chain becomes extremely difficult to reconstruct. This is why structured legislative data initiatives are so important. Standards that have been established within the domain, such as Acoma and TOZO, for instance, represents important steps towards machine-readable legislative ecosystems. The work supported by several countries and the United Nations Department of Economic and Social Affairs around Acoma and TOZO aim precisely at improving interoperability, traceability, and structured legislative exchange between institutions. I was very glad yesterday when I had an exchange with Monica Parirani, who said that to prepare the event of the 20 years of Acoma and TOZO that will take place in Bologna last year, she found back a letter I signed in 2014 supporting Acoma and TOZO for the United Nations. So you also find sometimes some piece of history in some documents you also forget that you may have signed. Well, that's interesting. And I believe this direction is essential because if legislation remains primarily designed for human reading only, large-scale AI-supported scrutiny will remain limited. The third requirement is governance. Governance here is not technological governance. It is democratic governance. Who validates the quality of the datasets? Who guarantees traceability? Who controls access rights? Who verifies methodological neutrality? Who ensures that politically sensitive evidence is not selectively interpreted? These questions become extremely important once AI systems begin influencing legislative oversight processes. Finally, legislators will need stronger cooperation across institutional ecosystems. No parliament possesses all implementation evidence internally. Relevant information may sit within ministries, regulators, supreme audit institutions, statistical offices, courts, universities, or even civil society organizations. Artificial intelligence may help connect these ecosystems, but institutions must first agree to cooperate structurally and share information according to common governance principles. Again, this was also mentioned before about the agreement of entities to cooperate with each other. And perhaps this is the most important lesson. Artificial intelligence does not eliminate institutional fragmentation. Very often, it simply reveals how fragmented our governance systems already are. The quality of AI-supported ex post scrutiny will therefore depend less on the sophistication of the algorithms than the quality, coherence, and maturity of the institutional ecosystem surrounding them.
Thank you. Daniel, same question.
So, okay, so we're talking about institutional requirements, which is fun.
Yes, yes.
Before I had talked about that we were in the ex post scrutiny world. So the question is, what does the post ex post scrutiny world look like? It's a lot of posts. I really appreciate Ludovic's comments. I'm going to talk about if his comments were at the level of principle, I'm going to talk about some application because we've been working on the application side of this in the United States. There are thousands of reports that are required by law for Congress to receive from the federal agencies every year. The way it works now is you send the report to a particular staffer in a particular committee, and maybe they keep it and maybe they don't, and that's, and it's lost. And if the committee wants it again, they have to go and contact the agency which may have it or they may have lost it. So Congress enacted legislation a couple of years ago called the Access to Congressionally Mandated Reports Act that requires all reports from the federal agencies to provide an essential location so that everyone can find them. So that if the House wants a report the Senate has or vice versa, it exists. And tied into that, the House clerk generates a list of all the reports that are due to Congress. Well, it's not actually all the reports that are due to Congress, but this would be a longer conversation, so I won't get into that. But it's a report of many of the reports that are due to Congress, and what one could do is simply align the list of what's due with the list of what's received, because we don't even know if the executive branch is sending the reports that are required by Congress to Congress or making them available in a central location. And this isn't just true for mandated reports, it's true for congressional budget justifications, which are when agencies ask for their funds. There are inspector general reports. We have 80-something inspector generals that generate thousands of reports. These reports are incredibly useful. They're available at a central website called oversight.gov, which went down last year when the Trump administration decided not to provide it the funding that it was required to provide. So legislative branch leads to another point, which is that data that the legislative branch needs should be held by the legislative branch. You should not be relying on the executive branch for information. When your legislative branch entities need information from executive branch or elsewhere, they shouldn't just ask for it, they should be able to demand it. There is a working group among the Congressional Budget Office, the Government Accountability Office, and the Library of Congress to make recommendations for what authorities they need to get the data sets they need from the executive branch and to empower them to do so, and there were legislative efforts to effectuate this. There was a similar law, time's going by, 15 years ago, the Data Act, which required the same thing for federal spending information. We didn't quite name it right, it's the Digital Accountability and Transparency Act, so it's actually the DAT Act, but we call it the Data Act because that was my mistake and I have to live with it. But there is a central repository for federal spending data that exists as a consequence of a parliamentary decision to make sure that it would be available. I mean, we're talking about AI, but AI is a layer above the decisions that we as members of parliaments have to make, which is that it must be available, we must demand it. We also tend to think 50 years ago or 100 years ago. We think about the structures in which we created things. So we have the Congressional Research Service, which has a pile of reports over here, and the Government Accountability Office has a pile of reports over here. We have the CBO, which has a pile of reports over here. They're all in different places, which means that if you're a congressional staffer, you have to look across those places and across the national academies and try to figure out what exists. This is not user-centered design. This is the opposite of user-centered design. So when we think about databases and places for information, we need to think about it from the congressional perspective where you've got 2 hours to answer a question, not from the bureaucratic perspective, which is, well, we created this agency 100 years ago and this one 50 years ago, so of course they should keep their reports in different places. And since this is an international conference, building on a conversation that has occurred previously, why are we just looking at national information? So the European Union has parliamentary research reports. The United Kingdom does, Japan does, Iran does. In fact, there are a number of countries that have these. If we're trying to analyze data, why are we reinventing the same data sets ourselves for each country? If we're spending $110 million a year on the Congressional Research Service alone, why aren't we building off of each other's capabilities? You can imagine a lightweight AI layer. So if you want to search the question of encryption or rising sea levels or CRISPR, which is gene research, why not look to see the different folks that have already done the research that we know that we trust, or at least have a higher level of trust, and build upon the data sets and information that exists there as well. Which is what gets to the point that was made earlier about transparency. Transparency isn't just about the public, it's about the internal stakeholders and the external stakeholders that don't talk to each other and don't share information with each other. There could be two people who sit next to each other for their entire careers and they never share their data sets with what the other person has. And this is a common occurrence. AI is useful to synthesize and summarize information. It's a useful way of gathering it together, but we have a governance problem with respect to the what you call the fragmentation, right? The separation of all this information in different places, and this is a parliamentary decision that we are making, but we can make different decisions to demand the right to have access to the information that we need in the formats that we need, and to design in such a way that we can find it built around the user and not built around political structures. Thank you, Wade.
Thank you, Daniel. Andy, over to you. Same question.
Thanks, Wade. And again, I'll approach this as a parliamentary counsel, as a legislative drafter. So I'll maybe just take the opportunity not to dig into some of the issues which my other panelists would do, but to just offer you something different and perhaps suggest something new just from my own perspective as a methodology for post-legislative scrutiny. Being a LegisTech event, of which I've attended a few, I'm sure you've heard quite a lot about law as structured data. We're quite fortunate we've had our statute book as structured data for some time, and a bit more recently we've developed some fantastic digital software which allows us to draft, amend and publish all of our legislation using Acoma Natosa, and it has structured data. So I'll maybe just use that as a bit of a theme for suggesting a methodology for post-legislative scrutiny. As I said in my last answer, and you picked up on this question, the material needed for post-legislative scrutiny is often fragmented in lots of places across government, through Parliament and courts, academic papers, the like. And we talked a little bit about how while it can be very difficult to assemble a complete picture of all this in practice, AI perhaps is going to offer a way of doing that a bit better. But having our legislation as structured data offers potential for a model of perhaps collecting that data. I wonder if I could perhaps suggest that it allows us to treat the legislation itself as the organising framework for that much wider body of legislation, to make the legislative provisions themselves, now being data, the hub around which evidence can accumulate. It can use that data to link to original policy objectives, original impact assessments, and then things later on like commencement information, guidance, and reports, reviews and audits and the like. From the perspective of a legislative drafter, this is particularly attractive, which perhaps why I suggest it, because legislation is already highly structured by us. We draft legislation usually by structuring it into things like parts, chapters, sections, subsections, schedules, the like. But legislation also contains other things which are identifiable and trackable, like powers, duties, definitions, review provisions, commencement provisions. These structures, I would suggest, can provide a natural point around which evidence of post-legislative scrutiny could be attached. Once legislation and evidence are structured together in this way, AI itself can then be much more useful by providing a way of navigating and analysing that knowledge. It can help us identify questions such as which provisions have generated the most litigation, which delegated powers have been used the most or perhaps never exercised, from a drafter's perspective, perhaps which provisions have been found to be most clear or most ambiguous, if that was unfortunate. And perhaps identifying, which provisions need to be amended the most, why do they need to be amended. Having legislation as data has already provided us with a sort of rich source of assisting the development of future legislation, as long as almost 10 years ago now, recognising that our statute book was structured data. We ran something, I'm sure now we would call it AI. It maybe was early AI, I didn't know the term AI back then, but we effectively analysed the entire statute book to try and identify patterns in the legislation. And we identified particular patterns. So, for example, whenever a criminal provision or a criminal offence was created, there was a particular pattern. Whenever a licensing regime was created, there was a particular pattern. Whenever a new public body was created by legislation, there was a particular pattern. And by identifying, we identified about 16 or 17 of these patterns across the book, the statute book, and then got together with colleagues across the UK and used that to collate all the different ways that these patterns of legislation had been provided, and then and turned that into guidance for policy officials who were perhaps then considering themselves creating a new offence or setting up a new public body, and saying, if you look across the statute book, these are all the things which perhaps you could consider. Once law as treated as structured data, we gain something new that did not exist in that sort of large, complex, paper-based statute book. We have a much better way of connecting legislation within that single knowledge system. And I think the example I gave, and also my earlier discussions about how it's able to bring together the fragmented statute book, will mean that if the law itself can be structured and can then be used as the method in which to create the feedback about it, this will make for a much more meaningful and continuous post-legislative scrutiny.
Thank you, Andy. As a drafter, you're speaking to my heart. So appreciate that. So for a final round just of closing, if you would just suggest perhaps one additional area of inquiry that would be useful to follow up as we think about really just legislative scrutiny to become more effective. And we'll begin here.
I think that when I listen to everyone else, I think it's very interesting in terms of how it would work in practice, but I still feel like I'm kind of stuck at the start of the whole debate. And I think that's, under reflection, I think that's because before we, start looking at how it would work, I think we need to be very careful in terms of the introduction of AI into this area of legislative scrutiny. Because of its impact, it's about talking about how laws impact society. And I think the first step that needs to be required is that we need to have very clear parameters around how it should be used, what we are doing it for, and how importantly it shouldn't be used. And that very clear line in the sand must be drawn, because I think at the end of the day, even when we're talking about trends and using it to measure outputs, AI is developed by a private actor with private interests. At the end, and a non-elected person is developing this program that can assist us. So it's just everything, there's risk, it carries risk. And we're not just talking about an organisational risk, we're talking about parliamentary risk, we're talking about democratic risk. So I'm very much supportive of it, but I do think there are limits to how, even though it could be used for so many great things, it could enhance, it could quicken, it could identify so many different effectiveness of legislation in many ways, but I think we just need to be so careful in that introduction, and a starting point needs to be the guidelines piece. It needs to be like, look, this is what we're doing here, but we're not ever going to go any further than this, and this is because that entrenches, or that goes into the democratic function. So I think that's my key takeaway, I think, for today. Thank you.
Thank you. Marty?
I couldn't agree more. Coming from Silicon Valley, our job in Silicon Valley has always been to destroy every institution and every structure in the world and replace it with our technology. And that is the ethos, and it has become more cutthroat and more driven by money over the years. I would say that, and I have a 16-year-old daughter and a 14-year-old son. They were raised with screens and technology that I was not, and none of us were. I have no idea what that effect is going to have on them. I have no clue. What I do know is that these systems are not based in truth, they're based in probability. So it's important that we stick to the truth and we stick to determinism. And that, you know, even the idea of human in the loop is nice, but we're malleable too, right? We adjust to the tech. I would start at a place where we use AI to feed deterministic systems, because that either works or it doesn't, right? What Grant described, what we're experimenting with, is not to build output for humans. It's to build output with AI for other machines, because the machines will tell us it works or it doesn't. It's a yes or a no answer, right? There's no analysis. It either turns on or it turns off. And now I can use my deterministic system to figure out what the AI got wrong. I would start by using data, manipulation of data, things that are really difficult. And then from the legislative perspective, the investment in a Comunitoso and being machine readable. We don't need AI for that, but it can help us drastically get there. And it can get us to something even further, right? We've all thought about this idea of rules as code or law as code. And that's where we can actually make our law very programmable, not to write the law, but to evaluate it afterwards with systems. So what did this law do? And this is where we can go even further. And by reaching for those things, it might help us understand how AI can actually be useful in this post world. But you have to start, and I know it's been said over and over again, by investing in the structure of your data. A Comunitosa is there, use it. Legal rule is there, use that too. I'll leave it there.
Thank you. Ludovic?
Well, I will just end for a question for you. Since when do you think that we are working in computer science about the efficiency of politics? You will just have to raise your hand. I will give you, let's say, a set of years, and just raise your hand if you think this is the right one. So between the 50s and the 60s and the 70s, let's say. 1. 70s, 90s. All right. 1, 2. 90s and 10. A little bit more. That's great. 10 and 26. I'm missing a lot of people. Yeah. 1. I think that since the first computers were invented in the 50s, and this was with, for instance, the Round Corporation in the States, which is 1952, if I'm not wrong, who are trying to evaluate the efficiency of policies. So the topic we are discussing today was discussed 70 years ago. And what are we talking today? We're talking about data, interoperability, probability, truth. are still at the same point, almost. Maybe a bit better, but we just progressed very slowly. Which means that if this would only be a question of technology, I don't think we will still be discussing this point 70 years after we started. Just some food for thought.
Thank you. I wouldn't have gotten it right. Daniel?
I didn't realize I was supposed to follow that. That's challenging. What was it? Was UNIVAC? Was that the first?
Right.
Oh, it was Rand Corporation? Yeah. So just a couple thoughts. Parliaments are information processing entities designed to generate outcomes. Right? We're talking about AI to help us do what parliaments are for. Collective decision making, a way to fight with one another without actually fighting, but to resolve conflicting information and try to make some sort of collective decision. So that's one. Two, we can try to put in place whatever policies we wish, but there will always be some subset of the parliament or some set of people that are going to rush to adopt and use new and different technologies, whether they should or shouldn't. So there will be some people inside our parliaments that will either internally in violation of the rules or will use it externally that are going to use these tools for things that we think that they shouldn't be used for. And we have to be ready for that, because that's going to change the very nature of the debates that we can have. And there will be a rush to compete. You know, when humans trying to deal with something that operates at a not human scale, that is a difficult circumstance. And I don't know how we resolve that. But it is the second thought. And the third, I'm going to make an incredibly obvious point. I think even more obvious than the other two, which is we need to disambiguate the term AI. Right? We talk about it, but AI is OCR. AI is natural language processing. AI is Gen AI. Some of these things, if they're deterministic, I think we're more comfortable with it. Some of these things, when they're non-deterministic, when they're help me with the word, they create, but they it's not hallucinate, but they propagate in certain ways. It's useful for some things, but there are a number of places where I think we are rightly really uncomfortable with it. I don't have answers, but I appreciate the opportunity to speak with all of you.
Thank you. Andy?
Thanks, Wade. Yeah, good post-legislative scrutiny obviously gives us to answer the question of how well did the laws which have been made work? Did they achieve a policy aim? As legislative drafters seeking good law, we look not only about achieving the policy aim in technical terms, but also whether law is clear and whether it's accessible. Laws need to be findable and understandable to the people they affect. If not, they're perhaps doomed to fail, no matter how sort of technically good they are. So for legislative drafters, post-legislative review can help us learn these things, can help us learn, you know, what's complex, what's ambiguous, and AI can be quite good at that. And I've put down some notes for this in my phone's notes app, and it's actually suggesting to me right now that I press a button and it will clarify what I speak to you. I haven't done that because I like to speak my own words, but you might benefit if I press the button. Who knows? We can maybe do it again and do some post panel review. So, I mean, just the speed of that, as I said in one of my earlier answers, I mean, what will AI's contribution to this be? I mean, I do think with post-legislative review, it's done in a sort of periodic manner at the moment. I think if AI can be used to allow us to get feedback on a much more ongoing basis, to have that sort of continuous feedback loop, then I do think that will generally be a good thing, but very much as a tool. And I would sort of like to just conclude by echoing what I heard from the panel there, AI as a digital tool, like anything else, is something to be used. Our laws are made by people. They're made by people we elect. I don't think we elect people to press buttons and make laws for us. We elect them to sort of have judgment and to be the people we've chosen to make the laws that govern our society. And I think I'd maybe just totally finish by the optimist in me hoping that our societies will continue by our democracies being us being represented by people we choose rather than by machines we choose.
Thank you. And I want to conclude as well by thanking everybody on the panel. It's been very helpful, I think, to bring out these issues. And recognizing that, my heart as a drafter, there have been so many times where I sit with a client and we work on a draft intended to address a problem, and we are making a guesstimate of what do we think the impact of our language will be. And my dream is, wouldn't it be interesting to be able to test that with some real data and adjust the language as we're going forward, and perhaps get a little bit closer to where we want to be, and then really have our system designed for that continuous feedback loop. You know, I mentioned it a bit yesterday, actually, with that continuous cycle, recognizing the dangers and addressing those at the outset makes a lot of sense. So thank you to everybody, and let's give our panelists a round of applause.